Later on during the interview, I had taken a brief break and I came back, and then he had said, I bullshitted you. I did just purchase another firearm, and it's in my desk. When I had asked him about the threats that were written in the letter, he said, no, not in that letter.
Detective, can you start by stating your name and spelling your last name for the record?
Yes, Shannon Malosky. Last name is Maloskie.
Where are you currently employed?
At the Adams County Sheriff's Office in the Detective Division.
And how long have you been employed at the Adams County Sheriff's Office?
For 7 years.
And are you the lead detective that's assigned to this case involving Matthew Britton?
Yes.
And how did you become involved in this case?
I was assigned the case.
What information had been gathered by your agency at the time that you're assigned to this case?
Initially, there was information regarding a letter that was delivered to a courthouse. One of the sergeants from the courthouse had been shown the letter and had done kind of a preliminary report on it, identifying a suspect.
Okay, so tell me more about this letter and how it came to be delivered to a courthouse.
Yeah, so the letter was actually initially dropped off at the Broomfield County Courthouse. One of the clerks there came in contact with the letter and then immediately notified the Adams County clerk in regards to the letter. And then from there, the letter came to the Adams County Courthouse.
All right, Detective, I've marked this as People's Exhibit 1. Can you take a look at the pages of People's Exhibit 1 and let me know if you recognize this exhibit?
Yes, I recognize this.
How do you recognize it?
This is the letter that was mentioned in the report and the letter that was dropped off to the Broomfield County Courthouse.
Okay. Is it a fair and accurate copy of what you recovered as part of your investigation?
Yes.
Your Honor, at this time, the people would move for admission of Exhibit 1.
No objection.
Thank you.
It will be admitted at this time without objection.
Thank you, Your Honor. Detective, who was the letter addressed to?
It was addressed to Chief Judge Kyle Seedorf.
Was there any identifying information in this letter that you received that led you to a potential suspect in your investigation?
Yes, so the letter was signed, thanks, Matt, as well as it contained an email address, mbritton, I think 54@gmail.com. And then the contents of the letter referred to a specific HOA case, an ongoing HOA case that was being handled by Judge Chanel.
You've talked with us about surveillance video from the Broomfield Courthouse. As part of that, were you able to see the vehicle driven by the male that drops off the letter at the courthouse?
Yes, there is a silver Mercedes sedan that was associated with the male that dropped off the letter.
And what was significant about that during your investigation?
During the investigation, we found that his wife, Casey King, had a registered 2006 silver Mercedes sedan.
And when you say his wife, who are you referring to?
Mr. Britton.
As part of your investigation, did you determine where Matthew Britton resides?
Yes.
On May 14th of 2026, as part of your investigation, was Matthew Britton arrested?
Yes.
Okay. And did you have the opportunity to interview Mr. Britton on that same day?
I did.
And is this the day after that letter was delivered to the Broomfield County Courthouse?
Yes.
Okay. Let's start by, do you see Matthew Britton in the courtroom today?
Yes, I do.
Can you please point out where he's seated and identify an article of clothing that he has on?
Yes, he's seated right next to the defense, and he's wearing the yellow and white top.
And for the record, Your Honor, the witness has identified the defendant.
The record will so reflect.
All right. Detective Malosky, you've just identified Mr. Britton here in court. Does he appear to be the same individual that you see dropping off the letter in the surveillance video at the Broomfield Courthouse?
Yes.
Okay. And can you kind of go through what Mr. Britton told you during your interview with him?
Yeah, so Mr. Britton, I asked him, to talk with me, and he immediately said, oh, it's about the letter. Said, yes, it was. He had explained his situation. He has been in an ongoing civil case with his HOA for several years. This case has cost him thousands of dollars. He's got the potential for assets of his to be seized, losing vehicles. During this case, there was a Judge Janelle, that was proceeding over the case, and he felt like she was not listening to him. She wasn't seeing his evidence. He had tried multiple avenues to bring up the case with the state, with the federal, with the Attorney General's office to get other people to listen to him, and nobody was listening to the evidence that he was trying to present for his side of the civil case. In addition, when I had asked him about the threats that were written in the letter, he said, no, like I didn't write threats, not in that letter. And he explained that there were several drafts to the letter. One of the drafts, when he was writing, he was very angry. And that draft may have contained threats, but the draft that he intended to be dropped off at the courthouse should not have contained any threats. He said that he understood the threats in the letter that was dropped off would sound threatening and would be something that he would be concerned about. He explained that while he was writing these drafts, he would have his wife look over them, and I guess when she had looked over them, she had accidentally given him the wrong letter to drop off at the courthouse.
Did he ultimately tell you that he wanted to have Judge Donnell removed from his civil case?
Yes.
Okay. And I know that you had said that he was or explaining to you that he was upset about his civil case. Did he use the words that he was pretty pissed when he was writing this letter about Judge Donnell?
Yes.
You said that you talked specifically with Mr. Britton about threats from the letter. Did you actually read him the direct quotes from the letter?
I did.
Okay. And so when he told you that he can understand how that might seem threatening, it was in response to you directly reading quotes from the letter?
Yes.
Did he talk with you about including information in the letter about the judge's personal residence?
Yes, he had said that he looked up her address and then found an image on Google Maps, and that was the image he used in the letter.
Did you ask Mr. Britton about any firearm that he owned or had recently purchased?
Yes. Initially, he told me that he did have a handgun. It was from his time in the service, and it was somewhere in the basement. He couldn't recall where. Later on during the interview, I had taken a brief break, and I came back, and then he had said, I bullshitted you. I did just purchase another firearm, and it's in my desk.
And did he tell you what type of gun that he had recently purchased that was in his desk?
He did, I believe. I can't remember specifically what it was. It was a variation of handgun, a black handgun.
Did you interview Casey King on that same day, May 14th, 2026?
Yes, I did.
And who is Casey King?
Casey King is Matthew Britton's wife. She knew that Matthew was writing letters, that he was angry. They were both very angry. She had recently noticed that he purchased a firearm, which is something that they hadn't had in their household prior to the recent events. She had noticed that he would stay up for days and nights on end, just writing letters, researching the judge, researching the HOA company, just sleuthing, essentially, is how she called it, how she described it.
Did she speak with you about any additional firearms that he was in the process of purchasing?
Yes, she had said that he had come home one day and mentioned that he had purchased a machine gun at a local pawn shop, an Easy Pawn.
Okay. After these interviews that you conducted, were you able to follow up with the pawn shop?
I was, yes.
And what did you learn at the pawn shop?
I learned that he had purchased a handgun on May 9th from the pawn shop. And then he also had an assault style rifle on layaway that he began payments on April 30th.
And just so the record is clear, when you say he, as it relates to this handgun purchase and the layaway payments, are you referring to Matthew Britton?
Yes, I am.
And what did Sergeant Larson observe about Judge Donnell?
She was frightened about the contents of the letter. She had indicated that she read it.
Was Judge Donnell asked if the photograph and address in the letter were actually of her residence?
Yes, she was asked that, and she indicated, yes, those were photographs of her residence.
And did Judge Donnell make any statements as to whether she felt threatened or feared any physical harm?
She did feel threatened, and she didn't want to return to her residence because of that.
I have no further questions at this time.
Okay, thank you.
Thank you. So let's talk about the contents a little bit further, okay? So I believe in paragraph 3 of the letter, Judge Seedorf is asked to reassign Judge Snell. Am I right about that?
Yes.
Basically, Judge Seedorf is supervising the judges in the district. Is that correct?
Yes.
And basically, Judge Snell was the judge for Mr. Britton's civil matter. Am I right about that?
That's correct.
The letter expressed that they believed that Judge Snell had a conflict of interest.
Yes.
It basically said that she knew the lawyers for the opposing parties.
Yes.
The letter expressed that he thought that the opposing counsel was trying to get a specific judge for that case.
Yes.
The letter does go into detail about believing that Judge Snell basically had property that was too expensive for her salary.
Yes.
Now, I'm going to talk about the specific language in that letter.
Okay.
Obviously, the letter has been introduced as exhibit.
Yes.
And there are, I believe, 2 paragraphs that you construed as having direct threats of violence. Is that correct? Or 2,
I don't recall how many paragraphs, but
or 2 sentences, I think, are we're looking at here.
I believe so.
Okay. So the first one was, personally, I would like to blow her brains out. Is that correct?
Yes.
Okay. Those statements were conveyed to Judge Seedorf in the letter,
Yes.
not Judge Snell.
Yes.
They are not saying that he will ultimately do these things.
Objection, relevance, and it's speculation.
Your Honor,
The objection's overruled. She may answer the question.
It doesn't say that he's specifically going to do these things.
there was another sentence there that said, if you don't reassign her today, you might be my tort lawyer because I might take her out. Is that correct?
That's correct.
And again, it's not saying that he will ultimately do that.
That's correct.
And neither of those sentences indicate that something would imminently happen.
No.
I have no further questions.
All right, thank you. Redirect.
Detective, you were asked a few questions about some of the contents of this letter. And specifically, you were asked about there not being any language about something imminently happening or any of these threats imminently being carried out, right?
That's correct.
Is there information included in this letter that reads, so please reassign her ASAP so I don't go to jail for hurting someone because I'm insanely pissed off and don't like liars and cheaters. It's up to you to do something today.
Yes.
I have no further questions.
They have finished their questions. You may step down.
Thank you, Your Honor.
Counsel, you may call the next witness.
And Your Honor, that is the only witness for the people.
Okay. Does the defense wish to call anyone?
No, Your Honor.
Detective Molosky has testified that during her interview with Mr. Britton, he admits to writing this letter, People's Exhibit 1. His wife also tells the detective that this letter is written by the defendant, and the court has heard testimony that he's seen on surveillance video delivering this letter to the Broomfield courthouse. The mental state for this offense is knowingly, and I think that the language in the letter that the court can review in People's Exhibit 1, as well as the defendant's actions in delivering this letter to the courthouse and then purchasing multiple firearms during this time frame show that this is knowing conduct that's practically certain to cause the result. The defendant's statements and his wife's statements support that this was retaliation or retribution against Judge Donnell. Both describe how frustrated they were with the legal proceedings and the very severe financial implications they were facing, bankruptcy, seizure of vehicle and their assets. They were very angry about what was happening. The defendant's statements in this letter are credible threats. This is a threat that would cause a reasonable person to be in fear for the person's safety or the safety of her immediate family. And the threat need not be directly expressed if the totality of the conduct would cause a reasonable person such fear. And specifically in this letter, there are multiple statements, one of which is, if you don't reassign her today, you might be my tort lawyer because I might take her out since they have fucked me out of $30K and want to seize all my property. The letter also states, personally, I'd like to blow her brains out after all the shit she's put us through. And also, so please reassign her ASAP so I don't go to jail for hurting someone because I'm insanely pissed off and don't like liars and cheaters. It's up to you to do something today. In addition to these very clear threats, the letter includes information about the judge's husband, a photograph of the judge's home, her address, and intimate details related to the home that suggest this isn't just taken from a Google map with no additional knowledge, which clearly the totality of this would cause a reasonable person such fear. But this language, coupled with the defendant's firearm purchase prior to the delivery of the letter, goes also to establish a credible threat. Now, the letter was addressed to Judge Kyle Seedorf. He is the chief judge for the 17th Judicial District, and he oversees all of the courthouse operations. It's very obvious from the contents of the letter that this is intended to be communicated to Judge Donnell. The intimate details, the threats, ultimately, Mr. Britton is trying to get Judge Donnell removed from his civil case. And finally, Judge Donnell, she's a sitting Adams County Court judge. She was presiding over the civil case that was described during testimony, and that was a legal matter that is involving Matthew Britton. So from this testimony, I think that people have provided evidence of all the elements for retaliation against a judge, especially given the standards that are used at this hearing, probable cause, and the evidence being viewed in the light most favorable to the people. So we would ask the court to find probable cause and bind us up to the district court.
And I think everybody in this courtroom has dealt with the standards for probable cause at preliminary hearings probably a number of times. It is clear that this court has to take the evidence in the light most favorable to the prosecution and construe any evidence in a light most favorable to the prosecution. In doing so, and in looking at the totality of all of the circumstances and drawing all reasonable inferences in favor of the prosecution, the court does find sufficient probable cause to bind up or over count one, retaliation against the judge. Again, the circumstances when taken as a whole are sufficient to believe that a crime occurred and that this defendant is the person who committed that crime. And Mr. Corey, it was your motion to modify the bond, and along with your objection to it being a cash-only bond, the bond schedule amount is $5,000, and this is substantially higher.
Mr. Britton's wife is currently present in the courtroom. He has pretty extensive ties to the area, and he has family who's able to support him. It's an incredibly high bond. We're asking for a reasonable cash surety or property bond. Reviewing the court or the prosecution's motion justifying the bond deviation, we do understand the concerns here. However, I think that there are appropriate circumstances that could be in place, including GPS monitoring, if that's appropriate, and relinquishment of firearms so that Mr. Britton can be safe in the community. We don't object to any of those conditions. And other than that, unless the court has specific questions, I will stand on my motion.
And do people want to respond to the request for the modification of bond?
Yes, Your Honor, and largely I rest on the information contained in the motion we filed to justify the bond deviation. For a Victims' Rights Act record, I would like the court to know that I have consulted with Judge Donnell, and she obviously has high safety concerns based on the nature of this case and would object to any reduction in bond for those reasons. In reviewing the defense's request for the bond reduction, it notes, the stable residence, employment history, and ties to the community. What's concerning to the people is that all of these things existed at the time that these threats were delivered and these firearms were purchased. So that's the backdrop of when this crime was committed. So the safety concerns from the people's perspective are very high, given these very specific threats coupled with the actions to secure not just one, but trying to secure 2 firearms in the very timeline that this letter was delivered. And given that that is one of the things that can be considered under the bond statute, in addition to return to court, is victim and community safety, the people would object to a bond reduction.
It is difficult for any judge to second guess what's going on with somebody and to try to guess what goes on if a bond is reduced. This bond is high. There's no question it's high. And the fact that it's a cash-only bond makes it even higher, of course. I will entertain a reduction to a cash or surety, but not as to the amount. The amount is appropriate for what has happened and under the circumstances that are presented in this case. But threats against judges are and should be taken very seriously. I won't go any further with that other than just to say, in addition, if that bond is posted, the court also orders that Mr. Britton obtain immediately mental health counseling. My recollection is it was $50,000 cash only, and then converted to cash for surety. Was it?
I'm sorry, how much did you, I just want to make sure, I think it's I just want to, before I misspeak, I want to look at my screen, but I believe it's $150,000 cash only.
Okay. Let's look at the screen and be sure.
I have $150,000 cash only.
Okay. The bond screen does indicate $150,000 cash only at this time.